Can Ripple beat the SEC? When will Ripple present new arguments in its defense? How much will XRP cost after the trial ends? We will answer these questions in today's video. In the meantime, subscribe to the channel and we're getting started. The legal battle between Ripple and the Securities and Exchange Commission, SEC, has entered a crucial stage as both parties await the final judgment date, which remains uncertain. Amid the lingering uncertainty, the case recently took a twist after Ripple filed a motion opposing a filing by investment banker Declarant, who is seeking to keep certain information private, including his name, position, and employer. The individual had previously submitted a declaration supporting the SEC's summary judgment motion. However, in the latest update, defense attorney James Phelan revealed in a tweet on January 25 that the investment banker Declarant filed a response to Ripple's opposition to their motion. The response partly argued that if their identity is revealed to the public, it will hinder future investigations, as witnesses might fail to cooperate over a failure to guarantee confidentiality. He called on the court to abide by its previous assessment that witnesses involved in the case face a high risk. The individual has maintained that he joined voluntarily, hence the need for protection. Therefore, the filing has added another layer of complexity to the case, as the court will now have to consider both sides of the argument for the legal battle in which Ripple is accused of selling unregistered securities in the form of XRP token. In this line, the matter is facing several contentious issues likely to impact the overall crypto space. The court's decision on whether or not to seal certain documents has become a contentious point in the case, with both Ripple and the SEC fighting to protect their respective interests. For instance, the focus is on sealing documents relating to the William Hyman speech, where the former SEC official stated that Bitcoin, BTC, and Ethereum, ETH, are not securities. As the legal proceedings come to a close, speculation about the possible outcome of the case has intensified. Ripple and the SEC have both expressed confidence in their chances of success, but Yu's lawyer John Deaton has pointed out it is not easy to predict the outcome. Additionally, it remains to be seen if the parties can settle after the ruling to avoid further appeals. The final ruling, in this case, is eagerly awaited by not just the crypto community, but also the financial industry, as it can significantly impact how digital assets will be regulated and treated in the future. Attorney Deaton achieved a significant victory on behalf of LBC token holders and the whole crypto sector in the just-finished hearing between LBRY and the SEC conducted yesterday at the Warren B. Rootman United States Courthouse in New Hampshire. Deaton, who acted as amici counsel for tech journalist Naomi Brockwell, successfully persuaded the judge that LBC secondary market transactions are not securities. In order to avoid giving clarification for LBC, the SEC sought an injunction that does not differentiate between LBRY, the company's management, and consumers. Attorney Deaton remarked that the injunction was imprecise and wide, forcing him to seek clarity for Brockwell and other LBRY users' LBC secondary market activities. The inventor of crypto law said that he referred to a paper prepared by commercial contract lawyer Louis Cohen that examined all security cases in the United States since Howard. According to Deaton, during Cohen's research of security cases in the United States, no court ever acknowledged that the underlying asset was a security. The article states that your ruling seems like you may be suggesting that LBC is security in and of itself. Deaton said to the judge in court, "If you don't intend that, Judge, then we need to explain it." After some back and forth, the judge said that he is not inclined to issue an injunction, according to Deaton. He went on to say that the judge's declaration is a huge victory since the court will not issue an injunction against LBRY users. Deaton said that he got the Securities and Exchange Commission to admit on the record that LBC secondary market transactions are not securities. Hearing on LBRY, the stakes for all crypto. Several Bitcoin fans have praised Deaton's efforts in the LBRY case, which might be employed in future crypto-related matters such as Ripple v. SEC. In a tweet today, Hogan law firm partner Jeremy Hogan praised Deaton for pressuring the SEC to state on the record that LBC as a token is not a security. The SEC acknowledged on the record that the token itself is not a security at the SEC's UV LBRY hearing. Excellent work, Mr. Deaton. Furthermore, Fox Business journalist Eleanor Terrett praised Deaton, noting that no one battles harder for the Bitcoin sector than the creator of crypto law. Takeaways. 1. In the Helbrackham case, the SECOV attorneys admitted author that secondary market transactions of L-sheep tokens do not constitute a security. 2. No one is more dedicated to the crypto community than Jan is more dedicated to the crypto community than consider how simple it would be for the SEC if it weren't for him. Elbrey has the following message for SEC. Ideal for the SEC. Ripple, the American technology company behind the Ripple blockchain and its native token Excerpt, has appointed a new president in the person of Monica Long. This development comes up amid the company's heated legal battle with the U.S. Securities and Exchange Commission. The appointment was disclosed by Ripple in an official press release on Thursday, and further publicized through its Twitter handle today. Starting the year off on a high note, we are excited to share that longtime Ripple and GM Monica Long's now president. Read more about her appointment. Long has been with Ripple for over 9 years, having joined the firm as Director of Communications in September 2013. She entered the scene when the Ripple workforce comprised only 10 employees. According to the press release, Long reportedly championed several initiatives that helped push Ripple forward, working with regulators and getting the trust of global financial institutions. Even in the current challenging crypto environment, Monica has helped guide Ripple to a very unique place of growth and financial strength. She's been an instrumental advisor to me over the years, and I'm grateful to have the opportunity to partner with her even more closely as she embarks on her role as president. Brad Garlinghouse, Ripple's CEO, remarked, Garlinghouse further acknowledged in a tweet today that Long has been one of the major catalysts of Ripple's growth over the years, highlighting her brilliance and effectiveness. There's a lot I could say about how singularly impactful Monica Long has been to Ripple's growth. For now, I'll just leave you with, she is brilliant, strategic, and has the ability to pick up and learn skills like no one I've ever seen before. Congrats, Monica. Long and her team were responsible for the launch of the widely utilized Ripple on-demand liquidity, ODL, enterprise crypto network in 2018. ODL, which is touted as Ripple's flagship product, is utilized by global entities and governments to facilitate cross-border settlements. Promoted to general manager in August of 2020, Long spearheaded CPC partnerships with Bhutan and Paolo, and the launch of the first stage of Ripple's Evans sidechain. The introduction of ETH on Ripple was also overseen by her. Moreover, the San Francisco Business Times has named her one of the most influential women in business. The recent development comes up amid Ripple's long-standing legal battle with the SEC, which has done little to stunt the technology company's growth. Optimism is dominant in the Ripple camp, as several individuals, including CEO Garlinghouse, remain confident of a favorable ruling. Garlinghouse also believes the case is likely to end in the first half of the year. Most recently, investment banker Declarant, a non-party in the litigation, filed a response to Ripple's opposition to their initial request to redact their personal information from a declaration in support of the SEC.